or do you want to?
Sure.
Andrew wants me to get us started. He's volunteering me since we have prepared such a thorough presentation. Um, I think I would just start by saying, the Disability Law Center is the state's protection and advocacy agency, which means we seek to enforce and advance the legal rights, choices, and opportunities of Utahns with disabilities, which means we represent the individuals, the people with disabilities in the state. And I know there are a lot of parents who have guardianship, and there are different perspectives on this. But the DLC's job is to represent the individuals and look at things from their perspective. And so what we often get calls about at the DLC, and we do get about 4,000 requests for assistance each year in a variety of areas, not just guardianship, but in a variety of areas. But one of the questions we get a lot are from people who have a guardian and it's not working out for whatever reason. They want to change the guardian. They don't want a guardian anymore. And so we often see when guardianships don't work out. I am certain there are many guardianships that work well for the individual and work well for the family, and that is great. However, we also think that there should be as many alternatives to guardianship that work for different kinds of situations than there are. And so there are powers of attorney, there are advanced directives, there are a variety of things that people can use. You can have a joint bank account if you just want to help somebody manage their finances that go outside of guardianship. Something is not as that doesn't require a court process or something along those lines. And so we're always looking for ways to expand options for alternatives. And one of the ways we thought we could do that is, looking at other states. Some states have passed legislation that codifies something called supported decision making. And so that's really what we want to talk about is kind of one, what supported decision making is, and two, there is legislation this year. It is HB 197.
197.
Thank you, Andy. Making sure I was going to get that right. So HB 197 that seeks to codify that. There was a bill last year that was very similar. There have been some changes based on feedback we've received from parents, and even like we reached out to the medical association to get doctors' perspectives. We kind of tried to cast the bar. We've cast a wide net trying to get feedback, and so we've made some changes to last year's. But the current version is public. It's HB 197. Happy to maybe when Andrew's talking, I'll try and find a link and put it in the chat, or maybe Aubrey can find that too. But so that is public now. So we want to talk a little bit about what that legislation is and some of the things it will do. And then really just answer questions and thoughts if anyone has any of that. So, Andrew, do you want to kick us off with some talking about sport decision making generally?
Yeah, I'd be happy to. And supported decision making helps can help adults with disabilities make their own decisions with the help of people they trust. And we all use versions of supported decision making every day. We can ask our parent for financial advice, or a coworker for recommendations on on the best car repair shop to use. So we all use supported decision making all the time. It's basically asking people that we trust and who have expertise in an area that we may not have, to give us their advice um, on how we can make the best decisions that we can for ourselves. The as Supported decision making can be used by people with a whole range of disabilities, from learning disabilities to intellectual disabilities, or mental illness. It can be even be used by older adults may who may be experiencing difficulty with memory or in other areas of their life because of age. Um, and I think the important thing to remember about supported decision making is that Nate talked about um, different types of alternatives to decision making and to guardianship. And while we hope that this will be one of them. The difference between the alternatives that Nate talked about and supported decision making is that with traditional alternatives to guardianship, um, the the authority to make the decision whether it is narrow or broad ultimately is given to another person to make that decision on behalf of the individual with a disability who it, or who is aging. Supported decision making, while individuals can help the person with a disability gather or understand the information they need to make a decision, the ultimate ability to make the decision remains with the person with a disability. It can cover a supported decision-making agreement a can cover a variety of areas, fi financial, health, education, or housing, among others. It can and the person with the disability has the ability to say who they want to support them or offer them assistance in different kinds of decisions. So it can be more than just one person helping you make decisions. And the role of the supporter is to help the person understand and explore options and explain the risks and benefits of choices and assist with gathering information or sharing ideas or helping a person communicate or carry out their decision. Um, and I think the most important thing that we want to note here is that supported decision making is simply another option. Person doesn't have to use it if it won't work for them, but that studies have shown that for folks who do utilize supported decision making, they see an increase in self-determination and that they are less likely to experience abuse. And so now with with that, unless there unless there are questions that we can handle now or questions come later, I'm going to turn it over to Nate to talk a little bit about what the legislation itself does.
Yeah, thanks, Andrew. I'm not seeing any questions now, so I think we'll just proceed. But again, I know Andrew and I are fascinating to listen to, but please jump in with questions if you have them. We really are happy to take those whenever. I think the first thing I would begin with, kind of thinking about the legislation is why. Why did we, as the DLC, like obviously we think there should be alternatives to guardianship, but why do we need to codify this? Because currently right now, there's really nothing preventing a person from saying, hey, I want to form an agreement with a group of people and have them help me make decisions. Why couldn't I do that today? Why does there have to be something in state code that says I can do that? And the answer is that there doesn't need to be something in state code that says you can do that. I think what we've tried to do is say that we want to help people understand what it is. And I think having something in code does a couple of different things. One, I think it makes it so that banks, doctors, judges, other folks know that it is a real thing that can be used, right? That it's something that they understand and recognize. So if you go to a bank and you bring a supporter with you and you say, hey, they're like, well, that person doesn't need to be in this room. These are financial decisions. Or you're with a doctor and they're like, well, you need to, you can't have this person here or something. It's just something along. I mean, we hear these problems all the time, even when people have guardianships. And so I think for us, it's trying to recognize something so that when a person goes with a supporter to something and they're kind of explaining things to them, working with them, that a doctor, a bank, somebody goes like, oh, that's what this is. This is a thing that is codified in law, and we all know what it is. So I think that's one thing, is just helping it be recognized by the kinds of places where this might be utilized. The other is, I think it's helpful, and I would add, I guess, for judges too. I think there could be instances where I think judges look at a certain instance and just understanding this as well. But the other thing I think it will do is that we can build some protections around it, so that this process can't be abused or used in a way that could potentially harm an individual. Because I know that's a concern we get. Well, my loved one, really couldn't do this because they need somebody to do these things or something. And so I appreciate that, and I think one of the things we want to be mindful of is that there are a wide variety of needs across the spectrum for people with disabilities, for people without disabilities, and kind of what it looks like for anyone. And so what we want to make sure is that when somebody utilizes this, when somebody actually forms an agreement with supporters, that it is, there are guardrails and guidelines about what that agreement should look like and who can use it. And then, protections if somebody tries to use it in a way that could harm an individual. And so that's really what we've kind of tried to look at when crafting this legislation. Andrew and I, in working with our sponsor, Representative Judkins, who we started talking to this issue about a few years ago, and just said, hey, what do you think about this? And we talked to her, and she thought it made sense. And so we're like, well, we need to kind of craft some language about what this could look like. And so we looked at a variety of other states across the nation that had passed this. We talked to people in the field, people experts who had worked around guardianship and alternatives for years, to get some of their thoughts on what worked in other states, what didn't work in other states. And we did our best to craft some legislation that did that. And I think one good example of one of the questions we had is, when we were trying to craft this, is some states have prohibited a person from paying a supporter, that a supporter can't be paid to be a supporter. And I think there's good reason for that. That could be a conflict of interest, right? You could have somebody who is being paid, and then can they really, help a person without some conflict arising with their payment? Or could they be like, well, I'm not going to make that decision if you're paying me. I'm not going to help you with that or something. So I get the concern why you would want to prevent that. But as we thought about it and talked to experts, one of the things that we realized is there could be an instance where a person needs to pay someone, that they don't have, maybe somebody in their life, they don't have a family or a friend they really could trust, and there could be somebody who they could utilize, but that person needs payment. Alternatively, there could be somebody who lives in a nursing facility and wants to utilize this, and a staff member there or a person in a group home, one of their staff is a really good friend of theirs, a reliable person they think they can trust, but that person is technically being paid. And so I think we wanted to avoid preventing that, because we think it could be useful for certain individuals. But ultimately, I think it's a question, right? Should that be allowed or not? And I think where the side we came down on, with our sponsor and talking through others, is that we don't think that should be prohibited. But then we had to kind of make sure that there could be other guardrails to prevent any, like I said, any coercion or undue influence from happening. Sorry, Andrew, I'm trying to pull up do you have the legislation in front of you? Do you have any, I can pull it up, I'm just asking.
Yeah. The some of the other things that we heard as we were talking to groups that could have concerns about this, or professionals that might be responsible for following it. And so we tried to respond to them by putting by making sure that we included safeguards, trying to put some guardrails around who who can and can't be a supporter for an individual. We also, as Nate was just outlining, our answer to to the individual who wants one of the staff members that works with them on a regular basis but gets paid to do so, to also operate as their supporter. One of the guardrails that we put in place is that the supporter has to disclose any actual or actual or perceived conflict of interest, and the steps that one, acknowledging that, but then also talking about what they the steps that are going to be taken to minimize or mitigate that. Um, and in response to some concerns we heard, we added language that says that the person can cancel any transaction um which a supporter engages in that could potentially benefit be a benefit to the supporter. The person uh can uh not can cancel that and say and not allow that transaction to go forward. We also uh, in response to especially feedback that we heard from the medical association, as Nate said, we um, made sure to include uh, guardrails and requirements around access to and confidentiality of uh, various information, and did our best to make sure that uh, a supporter who has access to this information is only using it for the benefit of the person that they are supporting. And then we also um, uh, we it's already in law, but we clarified and emphasized that anybody that a supporter or anybody acting on a choice or a decision made using a supported decision-making agreement uh, has a duty and a responsibility to report any suspected abuse, neglect, or exploitation um, that they observe or have reason to believe may be occurring. Um, in response to some concerns that we heard from uh, parents who are guardians, we explicitly require that if a supported decision-making agreement um, includes an area that touches upon a guardian's authority, that the guardian needs to sign off on the agreement and say that they are okay with it. And then we also in to make sure that the professionals who may be um, acting um, acting upon these, we included language to try to make sure are uh, that they are protected if they act in good faith in executing a decision um, made by a person using a supported decision-making agreement. Um, and then of course we we have a section of the um, legislation that talks about when an agreement can be ended, and can be ended by whom and for what reason or purpose. And uh, we made sure to clarify that the person themselves can terminate or end an agreement at any time that they would like. So um, I don't know if there are other things that you want to touch on, Nate, or if we want to open it up to questions if anybody has them.
Well, so far I've only seen one question, which Aubrey handled about the reporting, which will be made available. We do have a comment from Diana that says that the fact that this bill doesn't have a fiscal note attached is very good because legislators are often concerned with funding, and we would agree with that, Diana. We are very happy that there is no money in this bill. When you can have a bill that doesn't require any spending, your chances go up of getting something through. So we concur that having that happen is helpful to us. No, I think the only thing I would add, and I know Andrew touched on it a little bit, but I think some of the most important provisions I know because based on the concerns we got, look, I know there are people out there who have concerns about this, and I think those concerns should be we don't want to shy away from them. I totally understand it that people are looking at this and they're saying, I have a guardianship. Does this impact me in a new way? Or are you trying to take away my guardianship? And I do want to be clear that our intent is not to change anything for anyone who currently has a guardianship. We're not trying to say that you shouldn't have a guardianship or that it needs to be taken back. I do think that current code in Utah supports supported decision making as something that could be utilized for somebody who has a guardian. That the person you have a guardianship over, their wants and desires should be considered, where they want to live. Like those things are things that you should consider when making decisions for them. It shouldn't just be based on nothing. It should be based on their wants and desires. And I think that's what we're trying to say is if this works for an individual and their family, then it's something they could utilize. But it really, even if you do have a guardianship, you would not be obligated to use it. But it's certainly something that I think the principles of could be applied to somebody who has a guardian. But again, nothing has to change necessarily for somebody who has a guardianship, and guardianship would still be valid. But I think if you're somebody who's looking at the options of guardianship and alternatives, this is something we hope that people will look at and say, could this work for me? And I do see that we have one question, Andrew. We do have a real live question. Let me see. So it says, how do you create an agreement to make it meet the standards necessary for businesses and healthcare professionals to honor it? I'm happy to touch on that, Andrew. Or do you want to?
Well, I will start I will start off for the states that have done this already, and Nate mentioned it already, but at our last check there were 18 states and Washington D.C. that have formalized supported decision making in one to one degree or another. And I think for those of you who want to help us advocate in support of supported decision-making agreements in Utah, it's important to note that these are not just coastal blue states, but uh, Texas and Alabama have also adopted supported decision making as well, and I think that's great. What I will say is that we don't address we did have a discussion about whether to include a model form in a model form in the statutory language or not, and we opted not to do that because we wanted to leave um, the individual and their supporters with as much flexibility to create an agreement that met their needs, um, that uh, as long as it includes or complies with the requirements outlined in the legislation that we just talked through a little bit. We wanted to give as much people as much freedom to craft an agreement that met their needs in a way that makes sense for them. However, there are in states that have done this. several organizations have after the fact done uh, developed model forms that folks can use if they choose to, and also created education campaigns around around supported decision making and what it is and how and how folks can use it to accomplish their goals and objectives. Um, and we would anticipate that we might be involved in, if we are successful in getting this passed, that we would be involved in the future in helping to create um, in, in helping to create model forms, if there's a desire among the community to have those, or in helping to develop and create education processes around supported decision making and how best to make use of the process to help individuals and their families accomplish their goals and objectives. I don't know if you wanted to add anything more to that, Nate.
I mean, I think as Andrew kind of pointed out, I think the easiest way to think about it is I don't think there's like a specific way an agreement has to look for a business to recognize it. I mean, the legislation does kind of detail that it has to be in writing, have an effective date, designate at least one supporter, and kind of describe what they're going to do, and how it's going to look. And then it has to be signed by the principal and each supporter and a guardian. If it touches on an issue, a guardian has an issue of. I think we have a requirements of either, what is it, two witnesses or a notary. Um, and then if there's a conflict, that has to be dealt with, like we mentioned earlier. So if there's a conflict where a person is paid or something, that would actually have to be mentioned and kind of discuss or describe how that's going to be covered. And so, I mean, I think that really is what you would have to do. We didn't want to be, like Andrew said, too prescriptive. And so I think we wanted to give people an agreement that would work for them. But I think if it meets those terms, then really, if it's something in code, I think it's something that should be recognized by the entities you're describing. And so I think that's our hope. I mean, I think Andrew's right that it might take some education. And I think we hope that it will pass, that we'll have the opportunity to do some of that outreach and kind of letting people know about it, to make sure that it's something the public is aware of, and businesses. And so, I mean, I foresee that there could be some issues where like somebody's like, I don't know what that is, and I'm not gonna recognize it. And then that might just involve, kind of some education and things like that. So, that's just a possibility, but I think our hope is that it will work. So,
Yeah. And Nate, the other thing I will just mention very quickly is if there is a question of uh clarity or interpretation around one of these agreements, these the way that we have set it up in the legislation so far is that they are essentially a contract. Um, and so if there is a question or concern um, the about the validity of the agreement, or a question about how the agreement may be interpreted, that for whatever reason the parties can't resolve among the among themselves, there is the option to ask a court to take a look at the agreement and provide the um, court ask the court to decide whether the agreement is valid, or to provide an interpretation um, of the agreement that would then be binding on both parties.
Nate may be frozen. While we wait for Nate to become unfrozen, Andrew, we do have two more questions in the chat. I'm sorry, in the question and
No, you're
answers. Do you want me to go
currently
ahead and read
frozen.
those while we?
Good. Yeah, if you can
Okay.
hear me, I'll read. That would be wonderful. Thank you.
Yes. Yep, I can. Okay, so our first question is, for individuals interested in becoming a part of or creating supported decision making, are there informational resources you would recommend pointing them to? Specifically ones that will reflect the impact of House Bill 197 or any particular educational campaigns from other states they can start with.
The first part of the answer to that question is short, and that is we can't provide you that information about 197 yet because uh it hasn't passed yet. So, but once it becomes actual law, yes, those uh we uh we and I suspect others will be involved in creating those resources about basically what does this mean, and how might I use it. I am I don't have them at my fingertips at the moment, but we would if folks are interested in seeing what those kinds of materials could look like, and um there are other, as I mentioned, there are several other states who have not only passed legislation but also created the materials to go along with them, and I would be happy to be happy to share those, and they can be sent out following the webinar, so that you all can get an idea of what that could look like, or if once we actually have a statute in place, if you have idea based on those, if you wanted to let us know, hey, these are great, but we also think that you should suggest this, or add this piece to it, we would be happy to see all of that. So
Sorry, I don't know. I got booted off. I don't know. Andrew and I are on the same internet, so I don't know what's happening. But was that the first question in the one that Aubrey asked, the one about informational resources that you
yes.
could recommend? Okay. Um, and I think Andrew handled that. I can thankfully hear him right next to me. But so he handled that well. I would just add, I think the other thing to consider is if you're interested in helping this pass, I think there are a number of things we could also direct you to on
Yeah.
our website. We have a number of resources and fact sheets that kind of explain this. I think reaching out to legislators and letting them know
Yeah.
about this could be helpful. It's something that would interest you and your loved one. If it's something that would be helpful to your family, you think it's a good idea, we would encourage you to reach out to legislators
Yeah.
and talk to them about that. So,
And we don't, and I will just add, we don't know exactly when the bill is going to come before a committee, or which committee it's going to be in at this point. But if there are, well, one, we will be letting folks know through all of our social media channels, and probably on the website and in Policy Corner and all that. But if there are folks on the call this afternoon that would be interested in offering support for the bill, whether that's um, email whether that's emailing your senator or representative and asking them to support it, whether it's joining to testify before the committee on Zoom, or coming up to the Capitol. any of those ways would be welcome, and we would be happy um, to share that information with you as soon as we know uh, the when and how uh, when and how you can add your voice in support of supported decision making.
And if you want any of those resources Andrew just mentioned to actually view those, the website disabilitylawcenter.org is our main website. But if you want you can just go to disabilitylawcenter.org/issues/public-policy. If you'd like to go there, you can find all of the bill tracker, budget tracker, all these issues we're following, but this one in particular, and our policy corner videos where we update folks. And then I see we have another question, Andrew, that says, are there guidelines families should utilize to determine whether supported decision making or guardianship should be utilized? And I mean, I think honestly that I don't know that there are guidelines. I think it just kind of depends what works for what individual. I think from our perspective and from the perspective of, I think even the current state law and the way judges are, I think the state prefers a limited guardianship, and a full guardianship should only be granted when it is absolutely when it's something that's necessary. And I think the other is that judges should, when a person is when they're determining whether a person needs a guardian, they should look at whether alternatives have been tried, and if they were unsuccessful, why they were unsuccessful. And so I think our thought is that the guardianship is always an option that will exist for you at the end of the spectrum of options. And so I think there are probably people who need to jump to that maybe more quickly than others. But I think if it's something where you're like, could supported decision making work for me? And my loved one, or me individually, like it's something I want to try, I think you should try it. I think there's no harm in doing that because ultimately, if it doesn't work out, I think guardianship is something that you could utilize later. And I think that's true of anything. Maybe you don't go direct to guardianship. You say, oh, you know what? Supported decision making doesn't work, but maybe a power of attorney will, or maybe what I really need is a joint bank account that somebody can help me kind of manage my funds. Like there are just so many options out there that I think are worth looking at, that it's hard to say, oh, these are the guidelines you should absolutely follow, and this is what you need to do. I think it's a bit of, if this seems like it will work, then try it. And if it doesn't, then look at all the options. There's a range of options that exist, including limited guardianship, full guardianship, and then you kind of figure out which one will work for you. And I think from our perspective, going to guardianship is the one that you would try. That's the most restrictive form for the individual. And so I think you can always try other things first and see if they work.
And I will and I will add to what Nate said, just two quick things, and that is one, I think to the question whether supported decision making is appropriate or would work in a particular person or family's situation, is really as Nate said, dependent on the individual and the family, and sitting down and having a conversation. Does this make sense? Also, I think a factor to consider is, of course, do I have people in my life that I trust, who would be willing to act as supporters, whether that's family members, friends, or others. Do I have people that I think could be part of a supporter network for me? The other thing that I will say is that supported decision making does not have to work independently of other alternatives to guardianship, like that Nate mentioned, like a power of attorney, or an advanced healthcare directive, or a shared bank account, or any of that. You can have one or more of those things and still and have a supported decision-making agreement in another area. So, you can use multiple alternatives to alternatives, including SDM at the same time. So,
And thank you, Aubrey, for putting all of our fact sheets and our webpage in the chat for anyone who was curious. I think those are the things we developed that are helpful. So thank you. Okay, another question. I like when we have questions. It means Andrew and I can respond to things and not have to just keep talking. So for this bill, do you need to have a documented or diagnosed disability to create a supported decision-making agreement, or can anyone create this contract? Under the proposed legislation, a principal, which is the person who is the person who would form the agreement, would mean an individual who is 18 years or older, has a disability as defined by current state code, and then the person seeks to enter into a supported decision-making agreement with at least one supporter and has permission of a guardian if that applies to this. Honestly, I would have to go look at what that disability is defined as in state code. Do you know off the top of your head, Andrew? Are you gonna
I
us
would
with your
have to
knowledge?
double check, but I think we used essentially the ADA definition.
Oh, well, I know the ADA definition. For anyone who doesn't know the ADA definition, it is a physical or mental impairment that substantially limits one or more major life activity, which is interpreted very, very broadly. So, I mean, the answer to your question, I think, in the simplest form is yes. I mean, it's designed for an individual with a disability who would utilize this, though. I think if there was a great deal of interest in expanding this for other individuals, I don't know that it's something that couldn't be done or couldn't be expanded upon. And again, like we said, I don't think there's anything preventing people. But currently, under the proposed legislation, the idea is that this is designed for individuals with disabilities as an alternative to a guardianship or something like that. Do you have anything to add to that, Andrew?
No, but as we're continuing, I'll actually look up that portion of the code to make sure that we give folks the correct information.
Oh, goody, another question. Will the Utah Office of Public Guardian be required to limit their future guardianships and be required to use supported decision making? No, not under this legislation. We are not requiring anything of the Office of Public Guardian, or OPG, as we commonly refer to them. However, I would say, in my experience with OPG, is that they actually do, with the people they have who they serve as a guardian for, they actually do try to utilize kind of the same principles of supported decision making with those individuals. I don't know. I'd have to look at their regulations and code. I don't know if that's required of them, but my conversations with them, and from my understanding of kind of people who've been worked with them, that they really do try and look at what the individual's wants and desires and needs are, and kind of use that to influence the decision they make. So nothing is required of them under this legislation. They are not limited in the number of future guardianships. My hope would be that if there are instances where the state is involved as a guardian, I know they rarely try to hold on to a guardianship for an individual indefinitely. With OPG, they're usually looking kind of a short term, or finding ways to maybe do that. My hope is that they look at supported decision making as an option for some of those folks, as something they could say, we have a guardianship at this time because it needed to be in place for this reason. But as we look to move forward, that we can maybe help find them some supporters and utilize this. I think that would be our hope. But that's not required. But I think that's something they could certainly do. Do you have anything to add to that, Andrew? Or did you find the definition that you would like to share with us all?
I did. And no, I don't have anything to add to that, but I can confirm that the definition of disability in the bill is the ADA definition.
Well, there you go. We all learned something today.
Right.
Looks like we have a question in the chat. What situations would not accepting or refusing support that might cause bodily injury to the principal or others refer to? I know that refusing to take medication, follow healthcare directions like special diet are often a concern.
And this is actually a piece that we added to the bill in response to concern that we got from some family members about about what would what happens my if my family member gets injured or harmed as it by a I think the I think the intent the intent was by a supporter, but I think it can also be in yeah, I think the intent was by a supporter. So this was was language that we came up with because I think we settled on this language one because it exists in current code and it was a standard that is recognized in current code already. So we wouldn't be creating something entirely new, but also we wanted the standard to be to protect individuals um serious harm, but also be high enough that a high enough bar to clear that it would still allow them to um have to have the dignity of risk and the possibility of learning from from their failures without getting seriously injured in the process. So we chose this language because it seemed to be a balance between protecting protecting individuals from the from the from serious harm while still allowing them to um, ex experience and learn from failure because we all learn we all fail and we all learn from that and individuals with disabilities are no different when it comes to that. So this was just trying to balance the objectives of protecting the individual while allowing them to have uh, the same experiences as people without disabilities at the same time.
Yeah, and I mean, I think the important thing Andrew mentioned there briefly is one of the things we tried to really think through is that idea of the dignity of risk. I think that there is everyone gets to make decisions, everyone gets to make bad decisions. You know, we probably all did at one time or another. You know, there are choices we will make that are unhealthy for us. We might eat food that is unhealthy from time to time, and we didn't want we wanted to try and balance that and say that you know that just because a person might make a decision somebody else wouldn't think they should make, that they should be you know prevented from having this option of supported decision making. So we wanted to make it clear that you know if they were making decisions that might cause serious harm to themselves or others, that was kind of the line we had to draw of like where that would be. You know, we wouldn't want most people to do that. And so I think we were just trying to think through ways we could use definitions in current code to make that clear so that people did have that dignity of risk, because I think it's important. You know, I know that I have made many of poor decisions in my life that I'm sure that many people around me didn't think I should have made. And I think that's totally a thing that all of us are going to do at one time or another. And people with disabilities are no different. And we didn't want people to see something like that, like, well, they're making decisions I wouldn't make, so they aren't really fit for supported decision making. I think we wanted to avoid that. And so that's really where that comes from. I think there is a definition in code. If you click on where that goes to what I think serious bodily injury is, like kind of how they define that. And so that's kind of what we look to, is trying to make it as draw a line somewhere, because in the law you kind of have to do that. So well, I know we only have about what's 8 minutes left. I'm not sure there are any additional questions at this time. So I will put in a plug. If anyone has any questions, please get them in now. I think Andrew and I are happy to now 7 minutes answer those questions. But otherwise, I think we can, I don't know, Andrew, do you have any other last thoughts you think we need to mention on this?
No, but I will just reiterate that if anybody is interested in supporting the legislation, we will be happy to help you make that happen in whichever way is easiest for you. And also, if you do have questions or thoughts after the webinar, we want this to be successful, and we want it to work for as many people as possible. So if you do have thoughts or ideas about ways that we could do that, either now or hopefully once the bill becomes law, um, please feel free to share those with us, and uh, we will do our best to work with you, and um, try to make sure that um, that your thoughts or your input are reflected either either in the legislation or the steps that follow its passage. So thank you very much for joining us, and I hope that we hope that this was helpful for you, and only the first step in um, an ongoing conversation.
Yeah, and Andrew, we have one person, Andy, says he would like to help with this. So thank you, Andy. Please do. Aubrey has put our contact info in the chat. So yeah, as Andrew said, if there's something that comes up, a question that comes up after this, or you have thoughts or want to know more, please don't hesitate to reach out to either of us. Yeah, I think just thanks for coming and hearing us talk about support decision making. We think this is really important legislation that could have an impact on the lives of people with disabilities in Utah. So we hope you'll support it. We hope you'll do what you can to help, and don't hesitate to let us know if something comes up. But otherwise, I think we're going to end a little early. I'm there more. If you have more questions, don't. You got like 4 minutes, so we're here. But if not, we're happy to give everyone a few minutes back and just really thank you for coming to listen to our presentation today. Well, no one took us up, Andrew. So I think that's going to do it. That's going to do it. Thank you, everyone.